Divorce is highly stressful, and perhaps even more so for people who own a business. This is a highly complex area of law, and naturally business owners will worry about their business. Family law partner Sarah Atkinson is here to explain some of this to us. Let's start with the basics. What happens to a business during a divorce?
Well, they're factored in many different ways depending on the nature of the business. Sole traders are very easy, where the person themselves is running a business under their own name because there's no separate entity to value. Those with interest in partnerships or companies are slightly more complex. In some circumstances, purely the income that's generated by the business is shared on divorce, and it would be unfair on the business owner to count a capital value as well as the income stream it generates, because if you sold the business, you wouldn't then have the income stream, or vice versa. So then you'd only share the income long term with the spouse on divorce. If you're not going to do that, and you do need to be able to share the actual value of the business interest, then it will have to be formally valued sometimes to determine what that is if it can't be agreed, and then share the capital value between them.
Okay, let's look at that more closely. If it's necessary, how are businesses valued during a divorce?
The first step would be for the business owner to produce, as part of their financial disclosure in the divorce process, a valuation from the company accountants, because they know the business better than anyone and are best placed to do that. Sometimes there's a level of distrust between the spouses that means the court will appoint an independent expert accountant to confirm the value of the business. So it depends how that process pans out, really.
And what is involved if an independent valuation is deemed necessary by the court?
Well, we would select a single joint expert, they're called, in the process, and the solicitors for both parties would work together to prepare quite detailed instructions to the accountant, gather all the necessary documents they need to review. Those questions raised within the instructions would be to confirm the open market value of the business interest, i.e. what would a person on the street pay for that business interest. Secondly, we look at the tax consequences of selling that interest, because the court always works with net figures. So after tax, what's the business interest worth? Thirdly, it will look at the liquidity of the business interest, i.e. could the company release money to share the value of the shareholding with the spouse, and if so, how quickly and in what method, and what are the top tax consequences. And lastly, they'll look at the sustainable income of the business owner. So as part of divorce, sharing future income is sometimes done, and therefore you need to know what sustainably can be earned from the business going forward.
And what would you do with that valuation?
Well, the court has various powers available to it, and its primary aim on divorce is to separate the couple financially, so they each have their own assets independent of the other, and there's no future financial ties between them. So the obvious way of doing it would be for the court to order a lump sum payment by the person with the greater share of the assets, including the business, to their spouse to share the overall pot between them. If that's not viable, and it's not in every circumstance, then it's open to the court to transfer ownership of shares in a company, which can be quite scary for the business owner and maybe their colleagues. That can be shared in that way, so that the spouse becomes a co-owner of the business for the future and shares the benefit or the failure of the business as they would have if they'd stayed married. And in very rare circumstances, the court could even sell a business interest to release cash to share between them.
What would happen if a spouse already owned a business before the relationship had happened?
Well, the way the case law has developed, the court now categorises assets as non-matrimonial property or matrimonial property. And that matrimonial element is what's effectively built up during their marriage partnership. And that's definitely the element that would be shareable on divorce. So the court will try and identify how much the business was worth when it was brought into the marriage. It's very common these days with second marriages that people have built up wealth in this way, so that's why the case law is developing in that way. And they'll often do that just by taking a broad brush approach, because no one can look back to 1988 and determine the value of a company now and back then. It's very difficult. So they'll just apportion it over the period of time the business has been running normally. There are various complexities to that analysis, but the broad brush answer is they will ring fence an element of the pre-acquired value of the business.
So we've learnt from Sarah that divorces that involve a business can be very complex, and many people find it necessary to seek out specialist legal advice.